This is Earl White, real estate attorney. This is a video about the 5 most important factors the landlords must consider when they are entering to cash for keys or arrangements with their tenants, which is basically when a landlord pays the tenant money to vacate the property, usually because there's a mutually beneficial reason for the landlord also to have the tenant leave. First, every cash for keys arrangement should be in writing and signed by both parties. And if you want to be particularly covered, it should also be notarized. The reason you need to have it in writing because it's not sufficient if the tenant just leaves the premises. It can appear that it's sufficient because the tenant's obviously left, their belongings are gone, their beds are gone, and they've gotten their money, so presumably it's a done deal, right? Well, that doesn't really work that way because a tenant could turn around and claim that their tenancy is still intact. Just because they moved their things doesn't mean their tenancy was terminated. So even if it was just a verbal agreement and it goes to the court, it'd be he said, she said. So definitely need to have every cash for keys arrangement in writing and not rely on the behaviors of the tenant and the landlord to effectuate the agreement. Second thing landlord needs to take into consideration is that there needs to be specific language terminating the tenancy in whatever agreement the parties sign. It can't just be you leave the premises, because if you look at some forms online, they're not very well drafted. So it can't just be that you leave the premises and then you get your deposit back or whatever compensation the parties may agree to. It has to be the lease is terminated, and you should reference very specifically the parties to the lease, the date the lease was signed. If it's an oral agreement, obviously you can't do that, but as specific as possible, point to the document that was signed or the agreement that was signed to ensure that the tenancy itself is clearly terminated in the written agreement. It should also, the third thing the landlord should be aware of when doing these agreements is that it should be contingent and conditional on the tenant delivering the premises in the condition that it otherwise should have been at the end of the lease. So typically the standard for a lease is the tenant needs to deliver the property in the same condition as when they leased it, minus normal wear and tear. So you could reuse that language in the cash for keys agreement. But what you want to make sure you have covered in there is that the tenant vacates, but they don't get any of their compensation if the property is not left in the condition that I just mentioned. This way, you don't want the tenant, the tenant's leaving them, I'm sure they're not going to be particularly happy even if they're getting some money. So you don't want them to destroy the place on the way out. Or if it has to go, or if they do damage the place a lot on the way out, you don't want them claiming that now you have to pay them the money and then going to court and small claims court, wherever they may go for it, when the agreement didn't specify that. So you really needed it crystal clear in writing that has to be that the condition that it should have been left at the end of the lease, or even if it was oral, basically they have to leave it in good condition when they vacate in order to get their money for their cash for keys. Next question landlord needs to ask, number 4, is how are these funds going to be transferred? Is it going to be cash? Is it going to be a personal check? Is it going to be a cashier's check? So basically, the landlord and tenant have to agree on how the money is going to be transferred. Now, you could pro landlord, they vacate, you could mail them a personal check, right? So that'd be great for the landlord, but I don't know if the tenant may be not in position to might say, hey, I'm not going to move out until I have this money in my hand. Options to try to find a middle ground to keep the cash or keys together. Option 1, cashier's check. So landlord can go to bank, get a cashier's check made payable to the tenant, give a screenshot or whatever to show the tenant that this check has been cut to them, so they're confident that it's been cut. Then when they vacate, you can mail them a check or give them a pickup location. So that could be a middle ground where they feel comfortable that the money is in the cashier's check and that it'll give them an extra layer of comfort that the landlord is going to honor the cash for keys agreement. The other option, if the tenant's like, hey, look, I still can't accept a check. It's not money in my pocket. So I can only trust money in my pocket to know that before I move out. If that's the case, obviously it's not going to work for the landlord to put money in the tenant's pocket before the tenant moves out. So it's kind of a stalemate. So what can you do there? You can then utilize an attorney or someone similar to an attorney, maybe a property manager, friend, family, whoever the parties can agree to. I'm suggesting an attorney for holding the funds pending vacating. So what I've done in the past, when it's sensitive cash for keys type arrangements or comparable issues with the in those cases, hopefully the landlord then, what my recommendation here was be to give the money to an attorney because if you give the money to the attorney, both the tenant and the landlord can feel comfortable. The money's in a secure escrow account. The money has been transferred. The attorney is licensed. They have a duty of care and under the state obligations to be honest and trustworthy. So the tenant normally would say, okay, look, the attorney has it. I'm confident the attorney will release it to me upon the conditions being satisfied. And at least they know the landlord has put the money out and the attorney has the money. So obviously there might be some cost to have an attorney do it, but that's another option. But it probably comes up more if the attorney is already involved in a sale or drafting a lease or an eviction, something might have you. Which brings me to the fifth thing that the landlord needs to consider and understand when they're negotiating the cash for keys agreement. So question I'll get is how much should they pay the tenant, right? Because obviously that's going to be the fact. If you want to get rid of a tenant, you have to pay them $10,000, $20,000. I'm sure they'll happily leave. But landlord wants to pay them as little as possible, and tenant wants to get as much as possible. So can they meet on a middle number somewhere? What my suggestion here is that the question of the amount really comes down to the respective negotiating power of the landlord and the tenant. So where does the landlord have the upper hand for the negotiation? If this is relating to an eviction of a tenant or a tenant not complying with the lease or a tenant not paying rent, the landlord has a lot of leverage here to get a lower cash to keys number. Because look, they can go to court, they can evict the tenant for breach of the lease, they can evict the tenant for non-payment. So the legal cost to do that is what? $800, $1,000, $1,200, paying attorney. Landlords can do it pro se. So the point being, the landlord has the ability to get rid of this tenant and only pay the court/legal fees, right? So ain't no reason to pay them $10,000 or whatever crazy number they might want to have if you can get rid of them in 6 weeks at a much more reasonable number. So if you have eviction or some other grounds to legally get rid of this tenant in the near future, there is no reason to bend over backwards to pay them if you don't really need to. It still may be worth it to pay a smaller amount because maybe you can skip an eviction, get them out faster, get it released, keep them happy on the way out rather than being upset on the way out. So there may be a reason to still do it, but you have a lot of leverage as the landlord. Vice versa, though. The tenant has a lot of leverage if there's no grounds for eviction. So then you're basically asking the tenant for a favor. Maybe their rent is low. Maybe you want to sell the property and you can't sell it with them there. Maybe you want to move in quickly. So, or maybe in New Jersey, where we are, if it's more than 4 units, if it's more than 3 units, so 4 or plus, the landlord can't even evict the tenant to move in, right? So they would have to negotiate tenant to leave. So if there's no grounds to get the tenant out, the tenant basically has the right to stay in New Jersey, where we are, and therefore they have a lot of leverage. They basically go call whatever shot they want. So in that case, the landlord has a bit less leverage, so they're going to have to make the pot sweeter for the tenant to agree to the cash for keys arrangement. Now, look, they may be happy just to take their moving costs and get their deposit back and maybe some extra compensation for first month's rent somewhere else. That may be enough. But if the landlord wants to get this tenant out that perfectly have the rights under Anti-Eviction Act and other laws, protection laws in New Jersey, then that is going to be a high negotiation power on the side of the tenant. Okay, hopefully this was helpful. Landlords, as a recap, things you need to consider on your cash for keys arrangements. 1, get everything in writing. 2, make sure what you have in writing is crystal clear that the lease is terminated. 3, it should be conditional upon the property being left in the same condition as it was at the beginning of the lease minus normal wear and tear. 4, figure out how this fund is going to be transferred in a way that works both the buyer and seller. And then 5, think about that final number. And if you need this cash for keys arrangement, be aware if you have grounds to get tenant out, landlord got a lot of grounds, got a lot of negotiation leverage to get a number lower. But if not, landlord, you have to be realistic. You're probably gonna have to pay a little bit of extra premium there if you want to get the tenant out.